High Court slams brakes on new UK copyright trolling effort, published at TorrentFreak July 18, 2019. A judge at the High Court has denied an application from known copyright trolls targeting customers of Virgin Media in the UK. Mircom and GoldenEye, along with movie company partners, sought the identities of thousands of individuals said to have shared movies without permission. Citing a number of serious failings in the application, the court denied the request. Those familiar with the copyright trolling landscape against alleged file sharers in the UK will be familiar with the names GoldenEye International, and Mircom. The companies have a track record of targeting internet subscribers in the UK with demands for cash settlements to make supposed but non-existent court cases disappear. The companies have been quiet for years, but back in February attempted to resurrect their pay up or else scheme at the High Court. Neither firm was presented as the copyright holders in their Norwich Pharmacal Order application. Instead, they aimed to represent 16 pornographic movie company partners. The crux of the application was that ISP Virgin Media should disclose the subscriber details behind allegedly infringing IP addresses said to have downloaded the pornographic movies. The number of addresses isn't clear, but the claim that no more than 5,000 IP addresses per fortnight would be requested from Virgin Media and no more than 500 letters per week would be sent to subscribers hints at the scale. A High Court judgment published Wednesday reveals that Virgin Media put up a considerable fight to have the order denied, which is quite a novelty considering how compliant some ISPs have been in the face of similar cases. Douglas Campbell QC, sitting as High Court judge, indicated that Virgin's submissions had been very useful since the point raised by the company would probably have been raised by the subscribers had they been a party to the proceedings. The judgment traverses a complex web of privacy and data protection matters, including those related to the GDPR. While important considerations, little of that appears to have mattered. Ultimately, it's evidence that the companies simply failed to get their acts together. Submissions by Virgin pointed out that the evidence provided by Mr. Becker, GoldenEye, and Mr. Hoffman, Mircom, fell short, to say the least. To begin, the IP address list, crucial for the application to proceed, hadn't been presented as evidence in the application. Mr. Hoffman's witness statement is dated 26 February 2018, the judge responded. In paragraph 1, he explains that Mircom seeks disclosure of the names and addresses of the subscribers associated with the IP addresses listed in a spreadsheet attached as Exhibit 1, but there was no Exhibit 1. A terrible start, but there were further problems too. In a witness statement dated 26 June 2018, Mr. Wagner, solicitor for the applicants, purported to exhibit a spreadsheet marked MWH1, described as a spreadsheet setting out the IP addresses of subscribers for the period 27 February to the dates shown on the spreadsheet, the judge continued. This cannot be the same as Mr. Hoffman's own intended Exhibit 1, since it postdates Mr. Hoffman's witness statement. Further, this exhibit does not even set out any IP addresses, merely including an infringement ID which appears to be date-related. In any event, even Exhibit MWH1 is not what is sought. Mircom actually seeks the names and addresses of a spreadsheet which was sent to Virgin by email on 7 June 2019. This spreadsheet is not in evidence, nor is there any explanation of how it was produced. Claims by GoldenEye and Mircom that these were just technical issues were dismissed by the judge, who explained the errors and omissions as fundamental. Evidence provided by the applicant's supposed experts was lacking too. Mircom relied on an expert technical report by a Dr. Sare which supported the claimed effectiveness of infringement tracking software called FileWatch BT. That report was reportedly commissioned by telephone on April 1, 2010. I do not accept that I should simply assume that a 9-year-old expert report remains up to date, particularly one given in the field of computer software, the judge commented, noting that the report also lacked the required statement of truth to comply with civil procedure rules. There were also problems with Pfizer's statement, not least the claim that the software was used to identify the infringements in Exhibit 1, which of course wasn't presented in evidence. According to the judge, the evidence relied upon by GoldenEye, produced by Mr. Page, was somehow even worse. It certainly reads that way. There is no statement of truth, no clarity as to what his instructions were. His evidence refers to static IP addresses, not dynamic ones, and his evidence appears to relate to a software program called Observer, the judge complained. Yet Mr. Pfizer gave a statement, also unsupported by a statement of truth, dated 1st December 2017, in which he seemed to think the software mentioned in Mr. Page's report was called International IP Tracker. Virgin also drew my attention, without comment by the applicants, to evidence from Ms. Griffin, senior legal counsel of Virgin, suggesting that Mr. Page was a former detective who was arrested and dismissed after receiving a controlled substance. In response to these shortcomings, GoldenEye and Mircom requested permission to replace their expert evidence. Douglas Campbell QC denied the request, noting that the defects were fundamental. At this point, it's clear that the application for disclosure was already in disarray, but the judge still took time to address the other points that will be of interest to readers, not least the claim by Virgin Media that the applicants were part of a money-making scheme or shakedown. The judge said that in order to satisfy himself that the application was genuine, he'd need to know more about how how IP addresses, obtained by GoldenEye and Mircom as a result of their earlier claims, had actually been used. It transpires that following an earlier application, Mircom wrote to 749 people demanding settlement. Just 76 admitted fault, 15 settled without admitting liability, and 0 cases were taken to court. That raised questions about what happened to the tens of thousands of subscribers identified following previous orders and what their responses had been. This is not something which the applicant's current evidence addresses, nor is it information which they have offered to supply. Hence, this is a further reason why I refuse the application sought. The judge added, "The full judgment is available here."